Hello, this is Rob Pellegrino. I'm talking about the Chapter 13 in Plan Part 2, which really details some of the rights that a creditors may do under the plan, such as lien stripping. The plan created by your attorney is the most important document of the case. When confirmed, it binds all parties and creditors and may only be modified with court approval. While there are certain requirements which a plan must contain, there are also things that a plan may do. A debtor can choose to designate classes of creditors, such as secured and unsecured, and must treat each class fairly. However, the debtor has the right to designate classes such as consumer debts differently than other unsecured claims. The debtor may modify the rights of secured claims other than the security interest in the debtor's principal residence, or of the unsecured creditors, or choose to leave any particular class unaffected and provide for the curing of any default. As a practical matter, debtors who have certain secured claims with exorbitant interest rates can present a plan that reduces that interest rate that the creditors have applied against the property. Unsecured creditors are paid a small percentage of their totals based on disposable income. The most interesting aspect of the debtor's power in the plan is to strip off, or the lien stripping power. When an evaluation is done by your attorney, we look to see if the primary home, like many in Central Florida as well as around the United States, has lost value so that the value is proven to be worth less than what is owed on the first mortgage and the note. If this turns out to be the case, then any other secured interest in the property, such as an equity line of credit or a second mortgage, is now reclassified as unsecured debt and is treated in that class like any other unsecured creditor. Only a fraction of that debt is then repaid in the plan, and the remaining balance will be discharged at the conclusion of the plan. As an example, say your home has a first mortgage of $200,000, a second mortgage of $68,000, and an equity line of credit of $20,000. The market crashed, and now your home is worth $174,000. In this case, so long as you prove it's worth less than $200,000, you can strip off both the second mortgage and the equity line of credit, but you can't modify the first mortgage. You would therefore still owe the entire first mortgage, but pay only a fraction of the second mortgage and equity line as unsecured debt, called a cram down, then discharge the balance at the conclusion of the plan. For this and more detailed information about bankruptcy and the Chapter 13 plan, please contact me for a free evaluation and consultation at 407-574-5100, or visit my website at www.afreshfinancialstart.com. Thank you.